Start. This court, wide judgment dated May 6, 2020, decided as to whether the High Court, in exercise of its writ jurisdiction under Article 226 of the Constitution of India, could entertain a challenge to the assessment order of the appellant above named on the sole ground that the statutory remedy of appeal against that order stood foreclosed by the law of limitation stop. The SC in the present case, while allowing the present appeal and setting aside the impugned judgment of the Honorable Hyderabad High Court Hyderabad HC held that though the High Courts have wide powers, it cannot issue a writ which is inconsistent with the legislative intent of the concerned statute and in utter disregard of the statutory period of limitation provided thereunder, as the same would render the legislative scheme and intention behind the concerned provision otiose stop. The SC observed that the Hyderabad HC could not have entertained the writ petition of the respondent above named, while disregarding the provisions of Andhra Pradesh Value Added Tax Act, 2005, specifically Section 31 thereof, which provided for the filing of appeal before appellate authority within maximum 60 days. Stop para. The term period of limitation has been defined in Section 2J of the Limitation Act 1963 Limitation Act as the period of limitation prescribed for any suit, appeal or application in the Schedule of Limitation Act, further, prescribed period means the period of limitation computed in accordance with the provisions of the Limitation Act. Stop. Section 3 prescribes the general rule that, subject to the provisions contained in Section 4 to 24 both inclusive of the Limitation Act, every suit instituted, appeal preferred, and application made after the prescribed period shall be dismissed, although limitation has not been set up as a defense. Stop. Section 3 of the Limitation Act also clarifies when a suit would be said to have been instituted, for the purposes of Limitation Act. Stop. Section 5 provides that any appeal or application, other than an application made under any of the provisions of Order 21 of the Code of Civil Procedure, 1908 CPC, may be admitted after the prescribed period only if the appellant/applicant can satisfy the court that he/she/it had sufficient cause for not preferring the appeal or making the application within the prescribed period. Stop. Section 5 further clarifies that if the appellant/applicant was misled by any order, practice or judgment of the High Court HC/High Court in ascertaining the prescribed period, the same may be sufficient cause within the meaning of this section. Stop. Hence, the general rule of law of limitation is that an extension shall not be granted under Section 5 if there is no sufficient cause or cogent ground for the condonation of delay, the onus of proving which lies on the appellant/applicant. Stop para. The words sufficient cause, as appearing in Section 5 of Limitation Act, should receive a liberal construction when the delay is not on account of any dilatory tactics, want to bona fides, deliberate inaction or negligence on the part of the applicant/appellant, in order to advance substantial justice. Stop. The words sufficient cause for not making the application within the period of limitation should be understood and applied in a reasonable, pragmatic, practical and liberal manner, depending upon the facts and circumstances of the case. Stop. Over.